the society was a judicial employees society, and if anybody were to contend that a judicial officer, for instance a High Court judge or a Supreme Court judge, that he comes within the umbrella of judicial officer, that he would therefore qualify. We had very clearly held in that judgment that this category of judges, that is the higher judiciary, past or present makes no difference, could not under any stretch of imagination qualify for the definition of judicial officers. And I think, subject to correction, I think we had pointed out very clearly that this category of judges, they are constitutional functionaries. They are appointed by the President under the Constitution, and that they are constitutional functionaries. And having held that the status of a High Court or Supreme Court judge would under no stretch of imagination come within the definition of judicial officer, and because they were constitutional functionaries, there is no question. There was the High Court did not under any circumstances say, because it would be a contradiction. If you say constitutional functionaries are not judicial officers, then automatically they can't be qualified. You see, if you say that even after the judgment they continued making these allotments, my only comment would be that I would have expected them to follow the judgment of the High Court. My personal view, my conscience says that if you got a place to stay in, don't ultimately trade in housing, because housing is in short supply, and ultimately if you do it, you are depriving someone else of a place.